Hi, my name is Horatio Drumastregariou. I'm a lawyer with Connectors Law Firm, and I've decided to put together this little webinar about legal research and how to go about really finding the cases that you need to support the arguments that you want to make in court. This is a subject that can be a little bit complicated if you're not used to doing these steps, so I want to show you how I go about it. This webinar is intended primarily for self-represented litigants. However, other people that might find it useful include new lawyers and law students and other interested parties who might be going to court or just, if you have a passing interest in law. If you see me looking over to the side every now and then, that's because I have a little script there and a couple of things on it that I want to make sure that I cover so I don't forget anything. So a couple of things before we start, some housekeeping work. Number one, this webinar assumes that you have a basic familiarity with what a court decision looks like. I'm not going to go through and break one down. I'm not going to talk about the different parts of it. Number two, it also assumes that you don't have a basic familiarity with how search engines work. Whilst we will spend a bit of time talking about Boolean connectors and how that works in CanLii, this does assume that you've used Google pretty extensively and that your Google foo is pretty good to start. If not, I really recommend that you read some resources and watch some videos about that to sort of get a great head start on things. So some other things that this webinar won't cover is any specific legal rules. That's going to be outside of the scope of this, just so that we can keep things focused and in a specific amount of time. So next, why should you listen to me? What do I know about legal research that you might not? Well, I am a lawyer and I started my career off in civil litigation, which is very heavily research involved. For the last 5 years, I've been working in a legal AI company where we've been automating legal research using AI. I manage a team of 9 legal research lawyers, and together we work with engineers to produce high quality legal research for lawyers at all levels all across Canada. So we were regularly interacting with a lot with legal research, and we have ways to deal with it that might not be that apparent to people who don't do it as often. So that's why you should listen to me for these topics. Now let's move on to research sources. I'm going to discuss 4 sources, and I'm going to cover 3 of them. The fourth one I'm not going to cover, but I'm going to talk about it right up front. It's the National Self-Represented Litigants Project. They have excellent resources, they're really diverse, and they're specifically aimed at self-represented litigants. I actually have it open in this tab over here. And you can see if you go into SRL resources, you'll find quite a number of different checklists, coping with the courtroom, guides, primers, all sorts of things. Very, very useful. Reading and understanding case reports. Remember how I said that I wouldn't cover what a case decision looks like? Well, this covers it. So you can come to the National Self-Represented Litigants Project at representingyourselfcanada.com, and you can read all of that here. But we're not going to cover that. One thing I will cover very briefly is law firm blogs. This is an excellent, excellent resource for information for self-represented litigants and for lawyers alike. This is actually where a lot of lawyers start their research. So if you have a specific legal question in mind, rather than going straight to CanLii, you might actually go to Google and type it in and see what law firm blogs you get. The law firm blogs are usually quite well written. They're on specific topics of law and they're in depth. As well, they are also generally accurate because it reflects on the lawyer who wrote it and whose website it is, so they have an interest in making it accurate. Of course, they are just legal information and you shouldn't rely on them for your case. Now, the other 2 resources I'm going to talk about are ChatGPT and CanLii. You might be surprised with ChatGPT because we all know that it can hallucinate and that it's unreliable. That's true, and we'll talk a little bit about how it works later, and how you can mitigate some of that unreliability through different techniques, and how you can actually make it work for you fantastically well, even in legal research, even in highly topical areas. But what we're really going to do is we're going to do a bit of a dive into CanLii and how to find stuff on CanLii. Because the truth is that CanLii has millions and millions of resources, which is fantastic. It has cases, it has statutes, it has secondary sources, those being things like books and commentary by lawyers and others. It's a great, great place to find all of this. A lot of these materials have been relied upon in court, so they're authoritative, they're well written, and they're well thought out. So this webinar is going to show you how to narrow down and navigate through those millions of resources And it's also going to show you, once you've narrowed down to a specific case or piece of legislation you might be interested in, how to note it up, which means basically to check the history of how it's been used, to see if it's been overturned, if there's any issues with it, and if it's been overturned, obviously, for you not to rely on it. Now, without further ado, let's launch into talking a bit more about that. So let's talk a little bit about how you want to narrow down and navigate. First, you want to narrow down cases because, as we talked about, CanLii has millions of resources. You want it to be a number of cases that you can realistically check for relevance and that you can realistically read the ones that you are interested in. So what you're looking for is you want to narrow things down to about 15 to 20 cases maximum. Even that's a bit of a stretch, but at 15 to 20 cases, you can proceed through them reasonably quickly and realize whether they're relevant or not and whether you need to read them in more depth. So let's talk about how you do that. Let's search something that we know is going to give us a huge amount of cases, like just the word the. And predictably, we have over 1.5 million cases using the word the. So first of all, we have the jurisdictions filter. If we click on this menu, we can see that we have all of the various jurisdictions, and we can actually select multiple jurisdictions if we want. Say we want both federal decisions and Ontario decisions, we can select both. And all of a sudden, just by doing that quick switch, we've cut out about half the results that we initially had. If we leave it just Ontario, we have even fewer. Now, because we're talking mostly about family law, we might want to go into all subjects and select family. Of course, these tags might not be perfect, but they're pretty good, so it's a great place to start. In addition, we know that most family cases are actually decided in court and not a tribunal, so we can restrict it to the courts. Now, we'll see that since we selected family, it's actually already taken out all of the tribunals because there's just no tribunal decisions in this case that are relevant. But let's say we restrict it there anyway. So we can see that just by picking these three filters, we've reduced the number of results from over 1.5 million to 20,500. Now, that's still a huge amount, but remember, we just searched the word the. Now let's talk about Boolean operators. Boolean operators are how you tell a search engine, like CanLii, to do specific things. We're going to jump a little bit around the order that they talk about them in because they list them in the order of priority, meaning in the order that the search engine is going to consider them in, but that might not necessarily be the best way to talk about them. However, we'll start with the first one that they suggest because it is also the highest priority, and it's the star. It replaces 0, 1, or more characters at the end of the word. So in this example that they give, constru star, you will see if you search it, you get construction, constructive, constructing, construing, and construe, amongst other words that start constru. The next one is quotation marks. Quotation marks let you search for a phrase. So remember how child support gave us both child and support? Well, if we put quotation marks around child support, the 15,000 cases are reduced to 9,700, and we only get cases talking about child support specifically. The example they give is a case name. When you want to note up cases, this might be how you would search for a case to see if it has been discussed in others, using quotation marks. Next, I want to talk about the forward slash operator. There's three varieties. There's forward slash S, forward slash P, and forward slash a number, typically up to 500. Forward slash S means that you want the two words to be in the same sentence as each other. So, for example, we have child support as a phrase. However, we could also just have child forward slash S support, and this would give us all of the cases where the words child and support appear in the same sentence. Unsurprisingly, this is also going to be all of the cases that have child support as a term. However, you'll notice that this now has re-expanded what we have to 12,000. So that's not what we want in this case. So we're going to go back to child support with quotation marks. you'll see that it's expanded it to over 12,000 results. If we change the S to a P, that tells CanLii to search for the two words being in the same paragraph as each other. We can see that this will then increase it again. CanLii is thinking to 13,000. And not only that, but we now see again that we have the word support separated from the word child, because we've told the search engine that we're okay as long as it's just in the same paragraph. And finally, there's /n, as CanLii puts it, or a number, because n just is a stand-in for a number. This asks CanLii to look for the two words to be within a certain number of words of each other. If I recall correctly, the maximum is 500. So you can ask CanLii to search for two terms that are within 500 words of each other. For example, if we change the P to 500, this will further expand it, and we're actually back almost up to 15,500 cases, though we've still excluded 700 cases where the words child and support were more than 500 words apart from that case. And so you can start to get a feel for how you start to dive in deep and how you start to narrow out cases and look for the ones that you want. It's using these Boolean operators. They're so useful. So next I want to talk about brackets. Brackets give priority to an operator. Basically, they make a different operator more important. Because we have these different operators, we can actually combine them. We might combine the star with quotation marks and with one of these /n or /p items. In the example that CanLii gives, we have brackets contract /to sale close brackets, or, which is another Boolean operator we'll talk about shortly, seller. What this example is telling CanLii to do is, because it has the brackets around the portion that has contract /to sale, it's telling CanLii, I want cases where the word contract is within two words of the word sale, or I want cases containing the word seller. The brackets tell CanLii to give priority to that first condition, because without the brackets, what CanLii would see is to look for contract within two words of either sale or seller. And that is because the Boolean operator or comes above the Boolean operator /n in the list of priorities. So if you want to lift the priority of a lower ranked operator up, you need to use those brackets. Now let's talk about or. Or does what it says on the tin. It gives you cases that have either of the terms. It could be both, or it could be just one. Similarly, we also have and, which gives you cases in other documents that have all of the terms. The example they give is permit and hunting. So this would only give you cases where you have both the word permit and the word hunting in them. Similarly, there's not, which only gives you cases that don't contain the word that follows. So if you have custody, not child, we can put this in, and we actually see that we get very few cases, because there aren't that many cases in family law in Ontario in the courts where the courts are talking about custody but not anything about children. So now let's look at some examples of how you can use this to narrow down some cases and what this looks like in practice. So I'm going to go to the CanLii homepage, and imagine that I want a case involving the disclosure of banking statements for somebody who's self-employed. Well, one way that I could do that is searching with words. So searching for those topics. So I might put in statement, disclosure, and then I'm not sure if self-employed gets counted as one word or two word because it's hyphenated, so I'm going to put it in quotation marks, but maybe it doesn't matter. Let's check it out. Okay, we have 3,200 results. That's still quite a lot. That's more than I can reasonably look at. But we know that we actually only want court results. And we know that in this case, we want Ontario results. So that brings it down to 1,183. That's not too bad. Let's have a look further. Let's see if we can narrow it down further by only selecting family. And we can, 768. Still quite a lot. And in fact, CanLii even tells us that there's an extra decision we should add in from the Supreme Court. So let's go ahead and do that because the Supreme Court is the Supreme Court. Now, because we want cases that involve a disclosure of a statement, we might, of a banking statement or any sort of statement, we might actually want them to be in the same sentence as each other. So let's use that /s operator to get cases that contain the words statement in the same sentence as the word disclosure, and which also contains the word self-employed. And you can start to see how this works. This is likely to give you cases where somebody is self-employed or self-employment is discussed, and there's something discussed about a statement and disclosure. And we can see if we run that, that brings us down to only 226 cases. I know, it's still a lot. But CanLii only gives you a few to start with. So if we want to make it even tighter, let's put in a /p to have statement and disclosure in the same sentence, and all of that in the same paragraph as self-employed. And here we go. That brings us down to 23 decisions. That's pretty good. 23 decisions is a little bit over the maximum that we talked about before, but not much. At this point, we can start filtering it by either relevance or recency. And we can see that the very first case we have is a 2023 Superior Court case where one of the parties argued that disclosure of bank statements would be something that should be ordered. Oftentimes, what you want to do is you might actually want to sort by newest, not necessarily relevance, because this will have the newest, freshest law that's available. Of course, once you've done this, you do still want to note things up and you want to make sure that things are right, which we'll get to a little bit later in this webinar. Next, I want to talk about searching with phrases. So far we've talked about searching with words. As you can see, this sort of is like searching for a topic within a topic within a topic. We've searched for family cases within Ontario courts, and within that we've searched for cases where the word statement, disclosure, and self-employed are all there together. And we've actually asked CanLii to narrow it down only to cases where statement and disclosure are in the same sentence, and then all of that is in the same paragraph as self-employed. So what if we want to take a different approach? Well, you could search by phrase. So what that means is that because decisions are written by judges, you have to try and put yourself in the judge's shoes or one of the lawyer's shoes in terms of the arguments that they would have been making. For example, if I was to want to look for cases where a judge would talk about whether continuing supervised access is desirable or not, I would think to myself, okay, well, what would a judge have to say in a case like that? Well, they would definitely have to talk about continuing or ongoing access. They would have to call it supervised access because that is the term for it. And they would probably be talking about whether it's appropriate or desirable. So now let's think through, given the Boolean operators that we have here, what that would look like. Well, it's continued or ongoing. So let's write that in. Continued or, and it has to be capitalized, ongoing. And we know that we wanted supervised access. So I probably want that at the very least, to be in the same paragraph, /p, as continued or ongoing. And supervised access is 2 words, so because it's 2 words, we need to group them together using the quotation marks into a phrase. We open the quotation marks, supervised access, and we close the quotation marks. And finally, remember, I think that probably a judge talking about this is also going to talk about whether it's appropriate or desirable. So I want to make sure that continuing or ongoing are in the same paragraph as supervised access, and that is all in the same paragraph, let's start with, as appropriate or desirable. Let's ask CanLii what cases have all of that. And here we go, we have 64 cases. In fact, we even have a Court of Appeal case right up front. And we can see already that we start to narrow down into cases that are actually really helpful. Now, if you're in a situation like this where you still have more than 20 cases, you can start to look for them, and you can actually look at the cases to get an idea for other search terms. So let's have a look at this Court of Appeal case. We see, for example, that the words physically and verbally abusive appear. Well, if you only want cases where abuse is a subject as well, you might add in the word abuse, and that reduces it by another 50 cases. If we want to make sure that they're talking about abuse and supervised access, maybe we ask for it in the same paragraph. And here we're already down to only 7 cases. Now, 7 cases, you'll see that these cover the years from 1994 to present day. Of course, we've excluded quite a lot of cases, so you might have to go back and broaden out a bit more and read a bit around it. But we have a great starting point that gives you the language that you're going to be looking for, and it gives you the subjects that you're going to be looking for. If you feel it's too narrow, start to widen out. Let's have abuse not in the same paragraph, and we have 50 cases. Or let's not have the word abuse at all, and we have 64 cases. Every situation, what you want to do is you want to experiment and you want to rotate through different search terms reasonably quickly. If you're finding that something isn't paying off for you, you're not getting good results from search terms, try again. If you're finding that CanLii is telling you there were no results for what you searched, it's probably a little bit too narrow. You have to add in some ors, you have to expand the scope of things. In this case, for example, what would happen if we change the P's to S's, asking that this all be in the same sentence as each other? We see that the results are reduced to 10. So we see that mild changes like this can make actually really big differences in terms of what's available to you. Of course, this is a subset of the last one we looked at with the P's. However, the idea remains the same, is that you're trying to narrow in and out of subject areas to find the cases that you're looking for. So that gives you 2 ways to search. You can search with words, where you're searching for topics within topics within topics, and you can narrow down to find cases that way. Or you can search with phrases or portions of phrases, where you have to put yourself in the judge's shoes, think about what words they would have had to use to make the decisions that they make, and then search according to those using the Boolean operators that we talked about. Of course, you can also do a mix. And in a sense, what we've done in this search is a little bit of a mix, although I would argue that this is more phrase searching, but it's always up for interpretation. Finally, there's 2 more ways of searching that we're going to talk about. The first one is searching in cases. Let's do that with Sullivan and Seneschal here. We can see that it says treatment brackets 1. This means that this particular case has been discussed in another case that came after it. Once you have found the decision from which a point originates, you can look at how it's been treated in later cases to see how that law has been applied in different situations, and to narrow things down that way. For example, retroactive support is a hot topic currently, and it was made especially hotter by the Supreme Court's decision in Colucci. And we can go navigate to Colucci, and we can see that Colucci itself has been cited 365 times. Most recently, it seems like it's been cited in MacArthur and Lee. But already, just by going to Colucci and Colucci, which we know is about disclosure, which we know is about retroactive support, and about all of these things, by going here, we've already limited those millions of cases to potentially 300. So now we can browse within these. So let's say we want somebody that's self-employed. Well, we want all citing documents. We want to see all the cases that talk about Colucci. And then we can do the same searching here that we did previously. So within the cases talking about Colucci, and we do want to limit it to cases, which are only 344, let's search for self-employed. We see that there's 83 cases talking about self-employed. Well, remember we wanted statements. Well, let's have statements in the same sentence. And we're down to 11 cases. And so you see immediately we go from 300 cases to 11 cases. We narrow in, we hit that bullseye very quickly by using these Boolean operators and by thinking about where they're likely to be and which subsets of cases you want to look at. And again, to figure that out, look for law blogs. They talk about the more broad topics very often, and sometimes, and they'll often give you a leading case to go off of. Now, another way to search in cases is by specific paragraphs. So I'm going to go back to the Colucci case, and we're going to look at it together. In particular, we're going to scroll down, and we'll see that on the right-hand side, there's a heat map. next to the scroll bar. And the heat map is a list of paragraphs that have been cited in other cases. And we can see that there's this little icon next to paragraph 50, for example, that says 16. That means paragraph 50 has been cited in 16 cases. And we can click Citing Documents, and we can find, for example, only the cases that cite paragraph 50. So we know for sure that all of these 16 cases cite that paragraph. So, for example, if you go to a law blog, you find a discussion of a great case with a great paragraph, you can look that case up on CanLii. You can scroll down to the paragraph, and you can see if it's been discussed. Now, a word of warning, CanLii isn't perfect about capturing every single piece of discussion, and we'll talk about that a little bit in the noting up portion of the webinar, which comes later. But it's still a great place to start. Now, finally, you might want to look things up via legislation, which works very similarly. Let's take a look, for example, at the family law rules. We can select them and go into them. And we see here again that we have a Cited By tab, which lets us see all of the cases citing the family law rules. And in fact, each rule has a list of cases citing it. Rule 1 has 316 cases citing it. Rule 1.1 has 2 cases citing it. Again, we have a heat map on the side that lets us navigate to different rules, and we see different numbers of cases citing them. So if you want, for example, cases that talk about Rule 13, financial statements with application, answer, and motion, well, you can navigate to Rule 13 and then open up all of the citing documents and search within those. So again, let's say we want a self-employed party. Well, we just search self-employed. And all of a sudden, we've narrowed millions of cases down from millions to 25 cases involving self-employed parties where the court talks about Rule 13 of the family law rules. So you see, it starts to actually become pretty easy to navigate the law. Putting the right terms in can be a little bit tricky, but by doing this, you're actually giving yourself cases that talk about the right terms, and by going through the cases, you see what language the judges use, and you can start to put yourself in the judge's shoes using the same words for the topic searches and using the same phrases for the phrase type searches. You can use, as we've talked about, all of that in searching within cases themselves, within cases that have cited them, as well as within legislation and cases that cite that legislation. Next, we're going to talk about noting up, which means ensuring that you're relying on the right law and that the cases that you're picking are still actual and that they haven't been overturned and that there's no issues with them. Now, for noting up, let's get rid of this tab and go back to our search for child support. Remember, here we searched child support as a phrase, meaning with the quotation marks around it. We've limited results to courts, from Ontario, and only where the subject was detected by CanLii as family law. So let's say we want to rely on a statement of law, in this case, Dragala and Pauli from 2002. Now, since this case is from 2002, we can't be 100% certain that everything that's said in it is still correct today, because in that last 21 years, things could have changed. So how do we figure out if the case is still good? Well, after we read the case, which we can open up in a new tab, we can either check the Cited By documents linked on the search page, or we can navigate to treatment, which is the same documents. So let's go to treatment. As a general concept, what you want to do when you're noting up a case is you want to envision the case as a trunk of a tree branching out into different branches, different leaves. And each case that builds upon it, it's a different branch. And what you want to do is you want to essentially go to the end of the branches and make sure that there's nothing surprising there that you weren't expecting. So here, for example, what we would do is we would search for all citing documents. And you see that it automatically selects newest because this is of most interest to us. So we keep newest. We would go to cases because we're primarily interested in cases. And we would limit it to Ontario because if we're dealing with Ontario law, we probably are most interested in what the Ontario courts have had to say. So we see already that we've reduced some of the cases out and that we have some new recent cases citing the Dragala case and discussing what it actually holds. We can open up MacArthur and Lee, and then click the down arrow to go to where the search term was found in the case. And we can see that in this case, the court cites a statement concerning the imputation of income and the evidentiary foundation that's necessary for that. So we are sure by seeing this that that particular statement of law from Dragala continues to be a good statement of law and that it continues to be an accurate statement. Now, it is possible that this particular judge got it wrong. So what you want to do to make sure that it's not incorrect is you want to check a few different ones of the newest ones, and you want to make sure that the statements of law are the same in them. Judges do sometimes get things wrong, but generally, if a variety of different judges are all saying the same thing, it's pretty safe to rely on that and to follow that. This is known as a line of cases. What that means is that when you look at the trunk, sometimes sometimes the original holding is not very clear, so different judges might have slightly different interpretations about how the law should actually go. And so you would have one set of judges that thinks one approach is correct, and the other set of judges that might think a slightly different approach is correct. Those two approaches are known as different lines of cases. When you're noting up, you want to make sure that you've explored all the different lines of cases so that when you go to court, when you're presenting your case, you don't have a surprise when the other side brings out a case that you weren't aware of. Here, as before, we want to reduce the amount of cases to something that's manageable. 773 cases in this situation is not that manageable. So what I would do in this situation is I would check the newest cases. And then in the date filter, I would actually also search by court level. Because as we remember, a higher level court is more authoritative. And we see actually that we have a 2018 decision from the Court of Appeal, Levy and Levy. Let's open it. And now we've gone down to the portion of Levy that talks about the Dragala case, and we see again that the Court of Appeal is relying on these statements from that case, so we know that these statements are still good. Now, if we have any doubt about this Court of Appeal decision, we can do the same thing. And we can see again that these statements, there's 7 decisions citing them. And this is how you can make sure that the law is still current and that it's still correct, and that you have the best cases that you possibly can. Even if you start off with an older case, if you follow the different branches of that case to its most recent discussions, you'll find that you can be pretty certain about what the law looks like. Now, one important thing to mention is that a lot of these features are automated by CanLii. So that does mean that on occasion, CanLii won't actually show you all of the decisions citing a particular paragraph or a particular case. What you want to do in that situation is you want to just search the case name in the search bar as a phrase. Let's go back to Levy and have a look at what that looks like in action. Returning to the case and scrolling to the top, we see that 70 cases apparently discuss it. So let's see if that holds it true. Here we type in the case name and we hit enter. And we see that there's actually 72 cases that cite it. So what happened was CanLii actually missed 2 of the cases that cite it. It's always good to double check and to make sure that you haven't missed any cases, especially if they're higher level or more recent cases. AI is great, but it's never 100% perfect in labeling or tagging things. So it's always good to do these manual searches to just double check that you haven't missed anything newer, more recent, better than what you already have. Now, one final thing I want to talk about are Chillies. For that, I think it's best if we look at the well-known Colucci and Colucci case. So let's navigate to that. We can type in the case name and CanLii suggests it to us. You'll see in the treatment that the chili is now yellow. Let's click on that and discuss what that means. At top, we see that unfavorable mentions, the yellow chili, has 3 cases. That means that there are 3 cases which CanLii has detected as discussing Colucci in a way that isn't necessarily favorable. In addition, you'll notice that some of the decisions that are cited below, they have different numbers of chilies, and when you hover over the chilies, you see that it talks about discussion intensity. Basically what that means is how much does that case talk about this case? So if we navigate to this discussions tab, we see that this MAB and MGC case, 2022 Ontario case. This has 1, 2, 3, 4 Chillies. So it's actually a pretty intense discussion of Colucci. And surely if we open it up and scroll down to the first found term, in fact, we see that it is a pretty intensive discussion. And we see that Colucci is cited 48 times total in this decision. This is a way to find cases that discuss the case that you're dealing with in more detail. Of course, the more detail that a case is discussed in, generally the better quality of analysis goes into it, and the more persuasive that discussion might be. So whenever you're doing noting up, remember, you want to look at it like the branches of a tree, and you want to follow the branches out to where they finish. You want to make sure that the law has remained the same, that the same statements are being applied, and generally that there are new cases that affirm the validity of the case that you plan on relying on. Sometimes it's not going to be a huge amount of work. If it's a 2023 case, you can see MAB and MGC, there's only 6 cases citing it. That's just because not that many decisions get released. Other times, it's going to be more work. If you're looking at a decision from the 1970s, a lot of different things could have happened since then. You can cut the work down by going straight to the most recent stuff and seeing what that says, but sometimes you still have to look through a bit more detail. Noting up helps you ensure that the cases that you're using are good law, persuasive, and that the judge will accept them as they're written. It'll also mean that you know the law and how it applies to your situation. One final thing to mention on this topic before we move on to the last portion. I mentioned the word distinguish. A case that distinguishes another is a case which says the holdings in that case were correct. However, the facts are so different that we cannot apply those facts. Some cases are known as confined to their facts, which means that basically that's the only case that's going to be decided that way and only on those specific facts. And only should those specific facts ever come up again will another decision be decided that way. But there are many more decisions that are distinguished. An example of distinguishing features might be, for example, in a discussion about imputing income, whether the payor parent's employment is one of self-employment as a sole proprietor, or whether they're employed by a corporation that they own. That could be a potential distinguishing factor. I'm not saying that it is. What you'd want to do is you'd want to read the cases to figure out if it is. In every situation, you want the most recent, highest level, most factually similar cases possible, in that rough order. It's true, a higher court level does take precedence over something that's more recent. However, as I've stated before, if judges are doing their job correctly, and generally they do, recent decisions will cite the most recent law. Lawyers have an obligation to bring the correct law to the attention of judges, and with the exceptions of when that doesn't happen because of human error, they do. In all cases, you're going to want to note it up and you're going to want to make sure that the decision is still valid and that the courts are still treating the decision as a good decision. Now, let's talk about ChatGPT. Now, I bet that you didn't think that I would discuss this because it's unreliable, because it has hallucinations, because it's not confidential, and because of all of these other issues. And that's true. Those are all problems with ChatGPT. It is unreliable, it can't think or understand things, and it hallucinates. It can make things up because ultimately it's a program that's trained to produce text that sounds good and that sounds confident and that sounds correct, even if it isn't. But that doesn't mean you can't use it, and that doesn't mean that you can't get any benefits from it. Let's look at how you might be able to use ChatGPT to do some legal research. First, let's talk about the different types of ChatGPT. There is, of course, ChatGPT from OpenAI, where you can go and you can use the GPT 3.5 based ChatGPT, or you can pay for a premium subscription and use the GPT-4 based ChatGPT. GPT-4 is more capable than 3.5, however, it is normally a paid feature. Alternatively, you can get the benefit of using GPT-4 for free by using Microsoft Edge and BingChat, which is powered by GPT-4. You can also use the OpenAI Playground for increased privacy and security, but there's a lot more customizability there, and you might find yourself a little bit overwhelmed. If you want a simple interface, I recommend using BingChat through Edge. Let's open up BingChat from the top right-hand corner. There's different techniques to use to get ChatGPT to give you useful things, but one of my favorite things about it is that it's great for ideation. Even though it suffers from hallucinations and lack of accuracy, it's great for parsing different ideas and to just get through things quickly, to consider different things. So one thing you can ask it to do, if you recall earlier, we said to put yourself in the shoes of a judge. You can also ask ChatGPT to do that and to give you what might be an appropriate Boolean search for what you're looking for. So let's go ahead and ask ChatGPT to pretend that it's an Ontario judge and to give us 5 different searches using Boolean connectors that we could use to find cases about imputing income to self-employed parties. While it's thinking, another thing that you can do is you can actually ask it for cases. Now there you have to be careful because ChatGPT, not being a lawyer, it doesn't know what cases are persuasive, what cases are authoritative, or what cases are even good. So you have to do all of the traditional research and making sure that it's correct by going on CanLii. We'll look at that shortly. But first, let's look at the suggested Boolean searches that I found. So first we have a search where it wants cases that have imputed income in the same sentence as intentionally underemployed, in the same sentence as self-employed, in the same paragraph as Ontario. Let's see if that gives us any results. In fact, it doesn't, because it looks like that was a bit too narrow. So let's broaden it. Let's remove Ontario, because we can always filter that out using the filters. Now we have one case. In fact, the case that we have is a pretty recent case, and it talks about imputing income due to intentional underemployment with respect to somebody that has self-employment income. That's exactly the sort of thing that you're looking for. But let's say you wanted more cases. How could you broaden it out? Well, you could remove the requirement that self-employed be in the same sentence as imputed income and intentionally underemployed, and that raises the amount of cases to 109. Now, we can go through all of these and do basically the same thing, but the idea remains the same. It's put yourself in the shoes of the judge and think about what the decision would have to say to deal with the topics that you need to deal with. Now let's ask ChatGPT for actual cases. I've started a new chat to do this because ChatGPT remembers everything that you have written up to that point when you run a search, up to a certain amount of messages. Here we can see that ChatGPT on the right-hand side is thinking about cases and has suggested a number of cases already. One of the cases, Levy and Levy, the first one that it found, is one that we've discussed about already as something that came up in the noting up to Drygal and Powley, which is in fact the same case that which is in fact another case that we discussed earlier. You'll notice that it also found quintal and quintal, risen and risen, and pustai and pustai. So let's have a look and make sure that those are legitimate cases. Quintal and quintal does look to be a legitimate case. However, it's from 1997. The topics and head note do suggest that it talks about attribution of income and imputing income. However, because it's from 1997, it's not the freshest case, and it's also only a superior court case, so I might disregard it for better cases, or find better cases using the noting up function to find cases where its statements of law were repeated more recently. For example, Bolton and Wilson, where we can find quintal and quintal cited in paragraph 81. Now let's check out risen and risen. Risen and risen similarly is a 1998 Ontario case. Again, it's a little bit old, so what I might do if I want to find fresher law that talks about the same stuff as risen and risen is I'll go to treatment and I'll just start noting it up as I would normally. Now you might notice that a lot of these decisions are not from Ontario, the fresher ones. This tells me that this might not necessarily be the case that I want to rely on, and that there might be better cases for the statements of law that it contains. Now let's have a look at pustai and pustai. This is a more recent Ontario Court of Appeal case. This one looks like it could be relevant. Of course, you should read all of the cases. You should do the noting up like we talked about. This is actually the second take for this part of the webinar. The first time I did this take, ChatGPT suggested some Alberta cases, which, as we've talked about, we might not necessarily want to rely on in Ontario. There's probably better, closer laws that we can rely on. So just remember, whenever you're using ChatGPT for legal research, it's great. It can give you some great ideas for Boolean search terms, for connectors, for how to approach things, but you wanna doubt it and you want to double check. You want to note up cases and you want to make sure that you're using the best law that you can. So to recap, here are some things that we've discussed. We've discussed a couple of sources that weren't really within the scope of the webinar, just in passing. We talked about the ability to find great information at the National Self-Represented Litigants Project. We talked about law firm blogs being a great source of information because lawyers care about them and they do care about their accuracy as much as they are not legal advice and they're just legal information. We also talked about using CanLii, which is one of the best resources in Canada. It's free, it has millions of cases, and hundreds of thousands of other resources. We talked about how to narrow those results down and navigate into the 15 to 20 results that really matter to you and to your case and how to deal with them. We talked about noting them up, which means making sure that they're still good law. We also talked a little bit about ChatGPT and how you can use that, despite all of its problems, for legal research and how you can use it to give you a boost and to shorten the time that you need to spend doing this sort of stuff. Remember, it does have unreliability and hallucinations, so you still want to do the noting up and take some of the traditional steps in research that we talked about in the steps from CanLii. I hope you found this webinar really useful and informative. I hope that it really helps you get to the cases that you want quicker and better and easier. And if there's anything else that you'd like to know, please don't hesitate to reach out. You can find me on social media as well as on the internet in general, and I'm usually always happy to help. In addition, I might produce further webinars in the future talking about select aspects of the law, like consent orders, appeals, and other things, as well as more advanced research techniques. In any event, that's all for today's session. Thank you so much for watching and tuning in. I really hope you found this useful. Take care and bye-bye.